For a number of years, the only private sector regulations addressing modern slavery were non-binding guidelines issued by the United Nations and other international organizations. Recently, however, the legal landscape has changed with new domestic laws coming into force that address companies' modern slavery accountability. So let's look at some of the key features of these regulations. The state of California in the United States passed the first piece of legislation to engage the private sector on modern slavery. The California Transparency in Supply Chains Act, which came into effect in 2012, requires retailers and manufacturers who do business in California and have annual worldwide revenues exceeding US $100 million to disclose their efforts to eradicate slavery and human trafficking from their supply chains. The Act requires that the disclosure be made on company websites, giving consumers the power of information. Although the penalties for failing to abide by this regulation are limited, the California Act claims to raise more awareness of slavery issues and pressure companies to increase efforts to eradicate slavery. A second, more comprehensive piece of legislation is the UK Modern Slavery Act, Section 54, which came in force since October 2015. It requires any commercial organizations that provide goods or services, do business in the United Kingdom, and have worldwide turnover of at least £36 million to publish a yearly statement describing the steps they are taking to ensure that slavery is not taking place in their supply chains or businesses. This statement must be approved by the board and signed by a director. Companies can be in compliance with the UK Modern Slavery Act by publishing a generic or weak statement, as there are no penalties associated with the quality of its content. However, the aim of the Modern Slavery Act is to encourage companies to go beyond compliance by increasing their transparency and anti-slavery efforts. Similar legislation to the UK Modern Slavery Act is now being discussed in the EU, Australia, and other countries, which might include more severe penalties for non-compliance. In 2016, there were significant changes to the U.S. Tariff Act under the Trade Facilitation and Trade Enforcement Act. These gave Customs and Border Protection authorities the power to seize goods suspected to have been produced with forced labor, wholly or in part, in any foreign country. The act is significant because it allows any person who has reason to believe that merchandise is being produced with forced labor to file petitions with the authorities and alert them. Companies associated with the seized goods have 3 months to demonstrate that they are clean. The U.S. President signed a bill into law in August 2017 that provides sanctions for goods produced in whole or in part by North Korean convict or forced labor or foreign persons that employ North Korean forced laborers. Under the new law, there is now a presumption that any goods, wares, merchandise, and articles made by North Korean citizens or nationals anywhere in the world should be considered goods made by forced labor. As a result, U.S. Customs and Border Protection are authorized to ban and destroy any shipment they believe involves forced labor or prison labor. Other recent pieces of legislation on companies' accountability for modern slavery include France's Duty of Care law, which addresses companies' impact on the environment and human rights, regulations in the U.S. and EU that target specific commodities such as conflict minerals, and the U.S. anti-human trafficking provisions, which cover the U.S. federal government's procurement processes. This legislative shift has prompted the private sector to recognize that addressing slavery is now a business imperative.